Greetings, we're Group 10 and we're doing documentary evidence.
So documentary evidence is a form of real evidence. When a party offers a document into evidence, the party must authenticate it the same way any other real evidence is authenticated, either by a witness who can identify the document or by witnesses who can establish a claim of custody for the document. So the big question right now is, what is a document? So from Sikombe versus Attorney General 1919 TPD citation, which will be provided in the study notes, it is said the word document is a very wide term and it includes everything that contains the written or pictorial proof of something. So there's no generalized meaning of what a document is. The word document is wide, and anything can enter the threshold if the court does agree that it can be a document. So next, the types of documents, which are official documents. These can be your powers of attorneys, your land certificates, your contracts, your birth and marriage certificates. We have witness statements, which are documents, photographs and videos, correspondences. These can be private documents between two people, the letters you send to each other, notes of meetings, medical reports, and reports by other experts. There are ways you can challenge documentary evidence. Firstly, we have the parole evidence rule. With the parole evidence rule, extrinsic evidence is not allowed to prove the wording or the contents of the document. So if you look at our textbook, the recommended reading, page 183 to 184 provides for exceptions to the parole evidence rule. So you guys can go through that by yourselves. And then we also have authentication. With authentication, documents are authenticated differently. It depends on the classification of the document, which we'll deal with in a bit. And then also we have the best evidence rule. So section 15 of the Evidence in Civil Proceedings Act says only the best evidence is admitted. And this means that only the original document will be admitted. Copies will not be admitted, or anything which is not original. So this is in relation to documentary evidence in civil proceedings. And then documentary evidence in criminal proceedings, the law in Botswana is silent as to the best evidence rule. So because of section 276 of the Criminal Proceedings and Evidence Act, we have to look at the law in England. And in England, in the case of Kajala versus Noble, the best evidence rule was not used, which means that it no longer exists in criminal law. So we'll deal with section 244 to 246 which deals with the documentary evidence, but it only deals with official documents. So we'll deal with that to show you why we also believe that the best evidence rule does not exist in criminal law.
Lastly, we have an official document, and this is defined as one in the custody and under the control of the state by virtue of his office. State official.
Yes. So documentary evidence in terms of official documents is dealt with under section 244 to section 246 of the Criminal Procedure and Evidence Act. So firstly, 244 speaks about certified copies or extracts of documents admissible. So here, if there is an extract or a copy of an official document, it is admissible in court as long as it is certified by the head of department or an official where the document is under that duty. And then 244, production of official documents. So here, any original document in the custody or under the control of any government officer by virtue of his office shall only be produced in any criminal proceedings before any court or before a magistrate on a preparatory examination upon the order of the Director of Public Prosecutions. And then 246, copies of official documents are sufficient. So 246 also goes to say that even though the best evidence may not exist, being the original document, if you have a copy or an extract from the copy, then it is sufficient as being to be admitted before the court as evidence. So that is why I was saying I personally do not believe that the best evidence rule exists under criminal law. Looking at that our statute our statutes or our law is silent on it, and then when we look at the law in England, it no longer exists. And then looking at this section where it allows that if there's a copy or an extract, then it can be admitted as opposed to the original document.
So now we're going to be moving on to proof of the content of documents under private documents. So as we've already established, the best evidence rule is fundamental in the admission of the contents of a document. Under civil, we look at section 15 of the Evidence in Civil Proceedings Act, which states that the best evidence rule is the most fundamental. But then under criminal, we've already established that the best evidence rule does not exist anymore. However, there are some exceptions to the evidence rule, and these are where the original document has been lost or destroyed, where the original document is impossible or inconvenient to produce, where notice to produce the document which is in the possession of the opposing party has been given and he has failed to produce it, and where the original document is in the hands of a stranger to the proceedings. So under where the original document has been lost or destroyed, we have to do a diligent search to see if the document has been lost or destroyed. The South African case of State versus Miles, it was held that the state had not acted with reasonable diligence in its search for the requisite document, and as there was no ground for reading an implied notice into the charge sheet, secondary evidence of the document's content was inadmissible.
Okay, so another exception is where the original document is impossible or inconvenient to produce. A good example from the textbook is in inscriptions on a tombstone. Since it is physically impossible to bring the tombstone before the court as evidence, then getting photographic evidence of the tombstone, which would then be secondary evidence, is sufficient. And then sometimes you cannot produce. The impossibility may be due to impossibility because it is physically impossible to bring it, or it is legally impossible to bring it. So in these circumstances, it is allowed, even in civil proceedings, that you can bring secondary evidence. And then another exception is where original document is in possession of an opposing party. In civil proceedings, if the opposing party has the document, the original document, and they refuse to bring it forth before the court, then the other party who is seeking to bring the document and the opposing party is refusing can rely on secondary evidence. So if I am an applicant and my respondent has a contract that we've both entered into, and the respondent refuses to give the document forth, and I only have a copy or an extract from the contract, then I am allowed to rely on that copy or the extract as secondary evidence. And then in criminal proceedings, it is not allowed that you force people to bring forth documents because that particular document might incriminate them, and we know of the rule against self-incrimination. So in these situations in criminal proceedings, as we say, the first evidence rule does not exist. So you are allowed to bring secondary evidence which you are in possession of. Even if I'm not in possession of the original, I am allowed to bring it forth because the other person is entitled to refusing because that document might incriminate them. Yes. So the last exception is where the original document is in the hands of a stranger. So there are two approaches to this one. So in terms of civil proceedings. So firstly, if the stranger it's in the hands of a third person or a stranger, if the stranger has immunity, it can be diplomatic immunity or all the immunities we've dealt with, then they're allowed to, refuse to produce the document. And if they do not produce the document, then it is allowed that you can bring forth secondary evidence, because where you cannot produce the original, then you're allowed to produce secondary evidence. But if the refusal is unlawful, that is, you have no privileges and you're just refusing because you can, then you have to be compelled to bring forth the original document. So we can conclude if you can not lawfully refuse to bring the original document, the court will force you to bring the original document. So this means that secondary evidence in this instance will not be allowed. So now we are going to talk about proof of contents of documents in terms of public documents. So in terms of public documents, section 244 says a public document which is given like a copy of a public document or an extract of a public document which is given to the court by a person who has duty over the documents, then it is allowed that you should bring the document even if it is secondary evidence. So if the document, the secondary evidence is brought before the court by someone who has authority over the document, then it is allowed. You do not have to prove any further. And then this one is the obvious one from everything else. Marriage certificates, our omangs, and copies of our passports, we can bring them before the court, copies which are certified. So a great example would be section 11 subsection 8 of the Marriage Act 2000, which makes a certified copy of the marriage register prima facie evidence of the particulars set forth therein. So as long as the marriage certificate, the death certificate, or whatever certificate which falls under the regime of public documents, as long as it is certified, then you can admit it before the court as evidence. And then we have official documents. So we've already dealt with official documents when we were explaining section 244 to 246 of the Criminal Procedure and Evidence Act. So in criminal proceedings, in terms of section 246 subsection 1, the contents of official documents may be proved by a copy of extracts from the original certified as a true copy by the head of the department in whose custody or under whose control such a document is. So for example, if there was a witness statement and then they cannot produce the witness statement because the police diary was stolen, but the police officer had entered the witness statement into an e-diary, then the e-diary is only admissible if the head of department certifies that it is a true copy of the original. So that is the example I can think of. And then section 246 subsection 3 makes it unnecessary for any head of government department or office to appear in person to produce any original document in his custody or under his control. It is sufficient if a person authorized by him produces such document. If the original document does exist, then the head of department does not have to be there. You can easily authorize any person to bring the evidence or the document before the court. Section 245, the original document can only be produced upon the order of Attorney General. If we remember well, when in criminal procedure, when we're dealing with the rights which the accused people have, we did talk about where the prosecution refuses to give people diaries, police diaries, and other evidence. And there was a part where we said the Attorney General has to decide what exactly can be given to the other party. So that's all in relation to that. That is section 245. The Attorney General will decide what they want to give to the other party if the other party wants such documents to give to the court as evidence.
The next thing we'll be discussing is proof of authenticity of documents. As a general rule, a party tendering a private document must adduce sufficient evidence to satisfy the court of its authenticity. This means that the court must be convinced that the person who purported to have done so executed the document. Such execution is proved by showing that it was signed by the person by whom it purports to have been signed, and where attestation is required that it has been attested. With proof of handwriting, in the case of the thing versus the state, it was stated that there are at least 4 recognized methods of proving handwriting, which are by a person having knowledge of it from having seen the writer write the said document. This means that, take an example of us, that I should have seen him write the said document. By comparison of a disputed writing with any writing proved to the satisfaction of the court to be genuine. In this instance, the
document or writing in dispute would then be taken, and then another document that, for example, Pillar has written and the court agrees is a genuine handwriting of his, would then be put together in order to adduce whether or not the document in dispute is indeed a genuine handwriting of Pillar's or not. And then the third would be by expert evidence of a person who has adequate knowledge and skill as to handwriting acquired in the way of his business. In this instance, the court would then call in a graphologist who would then be able to adduce whether or not it is the person's handwriting. 3, by presumption, where, for instance, letters are sent direct to a particular person on particular business and an answer is received in due course, it is a fair but rebuttable presumption that the answer was written by the person whose handwriting it purports to be. We need to remember that this is a rebuttable presumption. So if evidence is brought forth that the handwriting is not genuine, the presumption will obviously be rebutted.
Another way of authenticating a document is by proof of attestation. Attestation means that the document is executed in the presence of a witness who signs by way of attesting the execution. An attested document could only be proved by calling the attested witness, even though the document itself be lost, cancelled, or destroyed. And where the attesting witness is dead, insane, beyond the jurisdiction, or cannot be found, secondary evidence of the execution must be given by proof of his handwriting, or if this is not obtainable by presumptive or other evidence.
In relation to this aspect of our presentation, there are no specific statutory provisions in Botswana for the admission of documents generated by computers. The general rule that content of documents must be proved by primary evidence will pose problems for this type of documents, as in many cases identifying what the original document is will be very difficult. So the question that may be posed now is that with regards to Section 276 of the Criminal Procedure and Evidence Act, the English statutory provisions relating to the admission of computer-generated documents are applicable to Botswana. That is the question posed. We as a group submit that whilst it is arguable that those English provisions may be applicable, the practical application in the courts of Botswana will be very difficult. This may be buttressed further by the point that by virtue of Section 28 of the High Court Act, the Chief Justice conferred with exclusive power to make rules for procedure that are applicable to the courts of Botswana. So this then shows that there's a contradiction, or the provisions of the English law and our law, they may be contrasted in that manner. And in the absence of such statutory provisions in our courts, the courts have found it very difficult to admit such documents, those documents being computer-generated documents. And this may be shown in the case of National Development Bank and Mbuli, where a computer printout was held inadmissible to prove a debt. And in the case of Tsalelo and Ngakemang Chombo, a printout was rejected as a liquid document in a summary judgment proceeding. And in the latter case, the question before the court was whether a computer printout was or was not a liquid document susceptible of finding sufficient evidence to grant a summary judgment upon. And in those proceedings, or in that case, both parties couldn't substantiate themselves because of the lack of statutory provisions relating to computer-generated documents. And then consequently, the judge held that it was the duty of the plaintiff to persuade the court that a printout was a liquid document, and then he couldn't, so the matter was dismissed. It is submitted that the current state of the laws of Botswana relating to the admissibility of computer-generated documents are not suitable for the reception of computer-generated documents. And the operation of hearsay rule and available statutory provisions for the reception of documents in legal proceedings were not designed to accommodate this type of document. We as a group believe that legislation should urgently permit computer-generated documents to be admissible, as has been other comparative jurisdictions.
We've now come to the end of our presentation. Study notes will be provided for further readers and you may refer to the textbook. Thank you.